Welcome to the Depth Dive. Today we're tackling something that really affects a lot of people living in shared properties. We're going to try and make sense of a key piece of law.
That's right.
Our mission is to, well, cut straight through the legal jargon and properly unpack the Sectional Titles Schemes Management Act, Act 8 of 2011. You might hear it called the STSMA.
Yep, the STSMA.
It's basically the rule book for managing these schemes, isn't it?
It absolutely is. And look, this act, it's crucial, not just for, property lawyers or law students who need to know the letter of the law,
Right.
but really for millions of South Africans. If you own or live in a complex, a townhouse cluster, an apartment block, well, the STSMA is working behind the scenes.
Oh, so...
It governs everything from like how often the garden service comes to why your levies are calculated a certain way, even how disputes are handled. Our goal today is clarity. We want to show you the core ideas, ownership, how things are managed, the governance structure that make it all tick.
Okay, good. Let's maybe start with a bit of history first, because there's something interesting there. The act was signed into law, assented to, back in June 2011.
That's right, 2011.
But it only actually commenced on October 7th, 2016. That's a 5-year gap. Why wait so long? What was going on there?
Yeah, that's a really important point. That gap wasn't just, administrative delay. The STSMA fundamentally changed how scheme governance worked. Before this act, a lot of the management rules like levies, meetings, that sort of thing, they were kind of buried inside the original Sectional Titles Act from 1986.
Okay.
So the STSMA basically pulled all that management and finance stuff out. It created a dedicated, separate rule book just for running the scheme.
Ah, consolidation.
Exactly. And that 5-year period, it was needed to actually set up the machinery to make it work, particularly the Community Schemes Ombud Service, the CSOS.
Ombud, right.
They needed to be up and running to, enforce these new rules and handle disputes when the act finally went live. So it was about getting the infrastructure in place.
Okay, that makes sense. So let's dive into the act itself, starting with the basics. Who are the main players? At the heart of every scheme, you've got the body corporate, or the BC.
The BC, yep.
Now, I own a flat, so technically I'm part of the body corporate. But what is it, practically speaking?
Think of it like the Homeowners Association, but with specific legal teeth. It's the official legal entity that's responsible for the whole scheme. And crucially, it pops into existence legally the very moment the developer sells the first unit to someone else.
Just like that.
Just like that.
Next.
And from that second onwards, every single owner in the scheme is automatically a member. You buy in, you're in the BC, you sell, you're out.
So it's a legal person, in a way. Can it, sign contracts?
Yes, exactly. It's a legal entity. It has what's called perpetual succession, meaning it just keeps existing no matter who the individual owners are at any given time. And yes, it can sue people, like for unpaid levies, and it can be sued maybe if someone slips on common property that wasn't maintained. But here's a key distinction. It's not a company in the usual sense. To keep things simpler and focused on property management, the STSMA specifically says the Companies Act of 2008 does not apply to bodies corporate. It's its own unique thing.
Got it. And what's its main job description then, the BC's core function?
Its fundamental role is the control, the administration, and the day-to-day management of the common property.
So hallways, lifts, the pool, the security fence.
All that. Anything that isn't part of an individual owner's section. And importantly, it has to manage this common property for the benefit of all the owners, not just some. It also has the duty to enforce the scheme's rules.
Now, you mentioned the developer starting things off. To make sure things run smoothly right from the beginning, the developer has some pretty serious obligations, right? Like handing over control properly. What does Section 2 say they must do?
Absolutely. Section 2 puts critical duties on the developer. It's like a handover checklist to protect the new owners. Within 60 days of the body corporate being established, remember, that's when the first unit is sold, the developer must call a meeting of all the new owners.
The first general meeting.
The very first one. And at that meeting, they have to hand over some key documents. First, a copy of the official sectional plan for the scheme. Second, a certificate proving all the municipal rates and taxes were fully paid up until the date the BC was established.
No hidden debts.
Exactly. And third, they need to provide proof of income and expenses. Basically, an accounting of all the money related to the scheme from the very first occupation up until the BC came into being. They also need to hand over any money left over.
That sounds like it's designed to prevent nasty surprises for the new owners.
It really is. And the Act backs this up. If the developer fails to comply with these duties, like not providing the documents or not paying over the remaining funds, it's actually an offense.
An offense?
Yes. punishable by a fine or even imprisonment for up to 2 years. It really emphasizes transparency and accountability right from day one. It stops developers from just walking away and leaving a mess.
Okay, that's serious. Right, so the BC's established, the developer has hopefully done their part. Now let's get to the part that hits everyone's wallet. The money. The funds. The STSMA brought in a big change here, mandating 2 specific funds.
Yes, this is arguably one of the most impactful parts of the Act for everyday owners. Section 3 mandates 2 separate compulsory funds. It forces long-term financial planning.
What are they?
First, you have the administrative fund. Think of this as your day-to-day operational kitty. It needs to be kept at a level that's reasonably sufficient to cover the estimated annual running costs.
So paying the security company, water and lights for common areas, the managing agent's fees, minor repairs, insurance premiums, that kind of thing.
Precisely, your regular, predictable operational expenses.
Okay, and the second fund?
The second one is a reserve fund. This was a game changer. It's specifically designed to tackle the problem of buildings falling into disrepair because no money was saved for major work. This fund must be built up and maintained to cover the cost of future maintenance and repair of the common property.
Future work. You mean like replacing the roof in 10 years or repainting the whole complex?
Exactly that. Not the routine stuff, but the big, planned, capital-intensive projects that you know are coming down the line. It stops the BC from suddenly needing to hit owners with a massive special levy because they didn't save up for predictable expenses.
So the admin fund is for the month-to-month, the reserve fund is for the long haul.
You've got it. And there are regulations linked to a mandatory 10-year maintenance plan that guide how much should be in that reserve fund to ensure the scheme stays financially healthy long-term.
And where does the money for these funds come from? Levies, I assume. Based on this thing called the participation quota, or PQ. Can you break down the PQ for us?
Sure. The PQ is basically your slice of the pie. It represents your individual share, your percentage ownership in the common property. And critically, it determines the proportion of the total contributions, the levies that you're responsible for paying.
How's it usually worked out?
Generally, it's based on the floor area of your section compared to the total floor area of all sections in the scheme. So if your apartment is, say, 100 square meters, and the total size of all apartments is 1,000 square meters, your PQ would likely be 10%. You pay 10% of the total levy contributions for the admin reserve funds.
Okay, that seems straightforward for the standard contributions. But what about fairness? Say I have exclusive use of a large private garden or maybe a dedicated parking bay that only I can use. Do I pay extra for maintaining that?
Yes, the Act addresses that directly in Section 3.
Yeah.
It includes what you could call a fairness clause. If an owner has a legal right to an exclusive use area, they generally have to make additional contributions to cover the costs specifically related to that area, like the upkeep of that private garden, or maybe specific rates or insurance related to that exclusive parking spot. The idea is that the person who gets the sole benefit of that area should primarily bear its specific costs.
Unless the rules say otherwise.
Correct. The rules can be structured to say the owner is solely responsible for all costs, like maintaining their own garden space directly, but the default is an additional contribution via the BC.
Right. Before we move on to governance structures, one last money point. Insurance. Sounds like a must-do for the BC.
Absolutely non-negotiable. Section 3.1 is very clear. The body corporate must insure the building or buildings to their full replacement value against fire and other specified risks, like storm damage, etc.
Replacement value, not just market value.
Crucially, yes, replacement value. And the Act explicitly states the BC is considered to have an insurable interest for this full amount. This means if there's a disaster, like a major fire, the BC has the undisputed legal right to claim the insurance payout needed to completely rebuild or repair the structures for everyone's benefit.
Okay, vital protection. Now, let's shift gears to power and control within the scheme. How does governance work? The BC has powers, but who actually wields them day to day? The trustees.
Exactly. The body corporate acts through its elected trustees. They exercise the functions and powers of the BC. But, and this is critical, they are held to a very high legal standard. They stand in a fiduciary relationship to the body corporate.
Fiduciary duty, that sounds serious. What does it mean in plain English?
It means they have to act with the absolute highest level of honesty and good faith. Their actions must always be in the best interest of the body corporate as a whole. That's all the owners collectively, and for the benefit of the BC. They cannot prioritize their own personal or financial interests.
So no self-dealing. Like, A trustee who owns a plumbing company can't just decide to give their own company the contract for fixing leaks without declaring it.
That would be a classic breach of fiduciary duty. They have strict duty to avoid any material conflict of interest. If a trustee does have an interest, direct or indirect, in a potential contract or decision the BC is making, they must declare it immediately to the other trustees.
And if they don't?
If they breach that duty, they could be held personally liable for any financial loss the body corporate suffers as a result. It's about ensuring trust and integrity in management.
Makes sense. Now, what about the rules that affect residents more directly? Pets, noise, parking, how you hang your washing. These are governed by the scheme rules, right? 2 types.
Correct. Section 10 outlines the rules framework. Every scheme is regulated by its rules, which are divided into 2 categories.
Okay.
First, you have the management rules. These deal with the fundamental administration and governance of the scheme. Things like how trustees are elected, procedures for meetings, financial controls. Because these are foundational, changing them requires the highest level of agreement, a unanimous resolution.
Wow. Unanimous. We'll come back to what that means exactly. What's the second type?
The second type are the conduct rules. These govern the behavior of residents and the use and enjoyment of sections and common property. Think rules about pets, noise levels, parking allocation, appearance of units, use of facilities like pools.
The day-to-day stuff.
Exactly, because they're more about daily life and less about the fundamental structure. Amending these requires a slightly lower but still significant level of consensus, a special resolution.
And can bodies corporate just make up any rules they like?
No, there's a crucial check and balance. Firstly, Section 10 states rules must be reasonable and must apply equally to all owners and occupiers. You can't have discriminatory rules.
And secondly?
Secondly, and this links back to the Ombuds service we mentioned earlier, any amendment, addition, or replacement of any rule management or conduct has to be submitted to the Chief Ombud for approval.
The Ombud gets the final say.
Yes. The Chief Ombud must review the proposed change and be satisfied that it's reasonable and appropriate before it can be officially registered and take effect. It acts as an external safeguard against unfair or irrational rules being imposed.
Okay, that's important. Now, you mentioned unanimous resolution and special resolution. These are obviously key to making changes. Can you break down the difference? How hard are they to actually achieve?
They represent very different levels of required agreement, reflecting how significant the decision is. Let's start with the special resolution.
Okay.
To pass a special resolution, you need approval from at least 75%, 3/4 of the owners present or represented by proxy at a general meeting. But crucially, that 75% is calculated twice. Once, based on the total number of owners voting, and again, based on the total value of their votes, which is linked to their participation quotas.
Yes. So 75% by number and 75% by value.
Correct. You need both thresholds met at the meeting. Alternatively, you can pass a special resolution if you get written consent from owners representing 75% in number and value of all the owners in the scheme, not just those at a meeting. This is used for things like changing conduct rules or maybe authorizing legal action against the developer.
Right. That sounds tough enough. What about the unanimous resolution?
Unanimous is the ultimate hurdle. It's reserved for the most fundamental decisions impacting the scheme. To pass it at a meeting, 2 things need to happen. First, you need a very high quorum. Owners holding at least 80% of the total votes, in both number and value, must be present or represented.
80% quorum.
And second, everyone at that meeting, 100% of the votes present or represented, must vote in favor. No dissent allowed among those attending.
Wow.
Alternatively, like with special resolutions, you can achieve it through written consent, but this requires the written agreement of every single member of the body corporate, 100% of all owners.
So literally one owner saying no at that well-attended meeting or refusing to sign the written consent can block a unanimous resolution.
Absolutely. That's the power it holds. It gives individual owners or even a small group holding more than 20% of the vote, preventing the quorum, significant veto power over major changes like selling off part of the common property or fundamentally changing the participation quotas.
That really highlights the balance or maybe the tension between collective decision-making and individual property rights.
It really does. It forces consensus building for major structural changes. But what happens if that system breaks down? What if the trustees are completely ineffective or maybe even acting improperly and the scheme is heading for disaster?
Is there an emergency button?
There is. It's an extreme measure, but Section 16 provides for the appointment of an administrator.
An administrator. What triggers that?
If there's evidence of serious financial or administrative mismanagement within the scheme, imagine Levies aren't being collected. Essential maintenance isn't being done. The finances are a total mess. Maybe the trustees are deadlocked and can't make decisions.
A crisis situation.
Exactly.
Mm.
In such a case, the body corporate itself, or an owner, or even a creditor who is owed money, or the local municipality, can apply to a magistrate's court. If the court agrees things are seriously wrong, it can appoint an administrator for a set period.
And what power does this administrator have?
They effectively take over. The court order gives the administrator the power to exercise all the functions and powers of the body corporate, completely replacing the trustees for the duration of their appointment. Their job is essentially to step in, fix the problems, and get the scheme back on a sound footing. It's a judicial rescue mechanism.
Right, a last resort. Okay, let's move into our final section. Dealing with conflict and consequences when things go wrong in other ways. What happens if the body corporate itself fails to act when it should? Say, the developer did shoddy work, but the trustees won't sue them. Or they refuse to enforce the rules against a consistently disruptive owner. Does an individual owner have any power?
Yes. Section 9 provides a specific remedy for owner recourse in this situation. It's a crucial check on BC inaction. If an owner believes the BC should be taking legal action, perhaps against the developer, or maybe another owner for breaching rules, but the BC refuses or fails to do so, the owner has a process to follow.
What's the process?
First, the owner must serve a formal written notice on the body corporate, demanding that it institutes the necessary legal proceedings within 1 month.
Okay, put them on notice.
Exactly. If, after that month, the body corporate still hasn't initiated the proceedings, then the owner can apply directly to the High Court.
For what?
For the appointment of a curator ad litem.
A curator ad litem. What is that, in simple terms?
Think of it as a court-appointed legal representative, usually an advocate or attorney. Their specific job, their mandate from the court, is to step into the shoes of the body corporate for the sole purpose of investigating and, if appropriate, pursuing that specific legal claim on the BC's behalf.
So it allows an owner to effectively force the BC's hand through the courts if the BC is unwilling or unable to act itself.
Precisely. It bypasses a potentially paralyzed or reluctant board of trustees for specific legal actions.
Okay, now let's consider the flip side. What if the body corporate gets sued, loses, and ends up owing a large amount of money, a judgment debt, that it simply cannot pay from its funds? Are the individual owners on the hook?
Potentially, yes. Section 15 deals with this scenario of unsatisfied judgments against the body corporate. If a creditor has a court judgment against the BC and the BC can't pay it, the creditor can go back to court.
To do what?
To apply to have the individual members of the body corporate join to the lawsuit as joint judgment debtors. If the court grants this, the creditor can then seek to recover the outstanding debt directly from the owners.
How is it divided up?
It's recovered on a pro rata basis according to each owner's participation quota, a PQ. So your liability reflects your share in the scheme.
That sounds quite scary for owners. Is there any protection?
Yes, there's a very important protection built in. The Act specifically says that an owner cannot be joined as a joint judgment debtor if they can prove they have already paid their share of the specific levy contributions that were raised, or should have been raised, by the BC to cover that particular debt before the judgment was enforced against members.
Ah, so if you paid your levies diligently towards that expense or debt, you're protected from having to pay again if the BC failed to collect from others or mismanaged the funds.
That's the principle. It protects the responsible owner who met their obligations from effectively subsidizing those who didn't pay or the BC's failure.
Okay, that's a critical safeguard. Finally, let's touch on the end of a scheme's life. How does the STSMA handle the legal destruction or winding up of a sectional title scheme?
Section 17 covers this. A building within a scheme is legally deemed to be destroyed, meaning the scheme related to that building effectively ends in one of three main ways.
What are they?
1. Actual physical destruction, like a total fire or collapse. 2. A unanimous resolution passed by all the owners agreeing to end the scheme. This also requires the written consent of everyone holding registered bonds or other real rights over the unit.
So the banks have to agree too?
Absolutely. The bondholders must consent. And 3. A high court order. The court can order a scheme to be wound up if it considers it just and equitable to do so. Perhaps if the building is derelict and uneconomical to repair, or if there's complete and utter breakdown in governance.
It ensures that ending the scheme is either a result of physical reality, overwhelming consensus, or judicial oversight.
Exactly. It protects the significant investments involved.
Yeah.
And just briefly, the Act also established an advisory council, the Sectional Titles Schemes Management Advisory Council, under Section 18.
What do they do?
They advise the minister on regulations under the Act, keep the Act itself under review, and generally provide expert input on scheme management issues. It includes the chief ombud, government officials, and people with practical expertise.
Okay, so there's ongoing oversight. Right. Let's try and wrap this up. This deep dive has really driven home, I think, the central role of the body corporate as the legal engine of the scheme.
That's me.
We've seen the absolute necessity of those two funds, the admin and reserve funds for financial health and avoiding future pain.
Critical for sustainability.
And the high standard expected of trustees, that fiduciary duty.
A cornerstone of good governance.
And thinking back to the start, you mentioned how the STSMA pulled management out of the old act.
Yes, it consolidated everything, management structure, funding rules, dispute resolution, rule changes into this one focused piece of legislation. It really centralized accountability and provided clarity, especially with the ombud having that final say on rules.
So, reflecting on all this, what's the big takeaway for you, the owner, the potential buyer, even the student learning this law? We've seen how much power rests in those resolution thresholds, particularly the unanimous resolution.
That's the really provocative point to leave people with, I think. The STSMA sets up this structure where incredibly high-stakes decisions like selling off a chunk of common garden for development or deciding whether to rebuild after a major disaster require near-total agreement.
The power of the veto.
Exactly. The refusal of just one owner or one major bondholder can completely derail plans that might seem logical or beneficial to the majority. It creates this enforced democracy within the scheme.
So the real power isn't just about who gets elected as a trustee.
Not entirely. While trustees manage day-to-day, the ultimate power on fundamental issues rests with the collective owners, constrained by those high consensus thresholds. So the STSMA forces every single member constantly to weigh up their own individual interests, their investment, against the collective good and long-term viability of the entire scheme. Understanding this act isn't just about knowing the rules.
It's about understanding that balance of power.
Precisely. It's about navigating that inherent tension in shared ownership.